Hello, everyone, and thank you for joining our program again. Good afternoon. This is our fourth and final session of our web series, Legally Speaking. This speaks specifically about a topic that I'm very excited about, and it is intellectual property. Now, our sessions covered in the past, we covered business entities, we covered contracts and commercial leases. So if you missed any of those sessions, we can provide the link, and we'll have a link to our website in the chat. So you can find on the COVID page, you'll actually find past recordings of different sessions. So hopefully you'll have an opportunity to watch some of those on demand. Now our next session, which is next week, actually the 27th, is on bonding. And we will cover the what, the why, the how, and when you need bonding. A lot of people are confused about bonding, if they need bonding. A lot of times if you deal with the government and have government contracts, you actually will need some kind of bonding. So it's an important topic that we want to discuss and we want to cover and serve you some really good stuff during lunch. So I hope that you are able to join us for all of our lunchtime webinars, and just log in and we will deliver the experts to you. Now, my name is Sidoni Naismith, and my company is Black Swan Events, Inc. It's an event management company and a business consultant firm. So we help businesses grow, and we help them to bring their people together in an impactful way. Now, this program is brought to you by Black Swan Events and the MBDA Export Center, which is operated by M. Gill & Associates. Now there's a program that was developed called the MBDA COVID-19 Recovery Initiative, which is an M. Gill & Associates project that is funded under the CARES Act grant from the U.S. Department of Commerce, MBDA, and it is managed in Broward County by Black Swan Events. So what that means is that my firm is able to help your small business to provide technical assistance, and especially for those that are impacted by COVID-19. So if you are in need of help, please reach out to us. Our contact information is in the chat, and a link is also there to our website. Our COVID page will show you a brochure with a list of things, of services that we are able to help you with. We've had companies reach out to us for something as little as a capability statement and as big as just trying to find contracts. So we're able to help you in that way. Now, before I get started, I always want to thank you for your time, for investing this time to get some new useful knowledge, for growing your business, and for you to just reserve this time for you and your business, like I said. For guests that have joined us in the past, thank you. And for the ones that are here for the first time, I look forward to seeing you at our events that are coming up. And again, you could go to our website to view any of the other business related webinars that we have hosted in the past. I always try to get an idea of where people are joining us from. So if you don't mind, I'm going to launch this really quick poll just to see what county you are actually joining us from. All right, give you a few seconds to finish that. People are still voting, so give you a minute as well. All right, I see some more votes still coming in. All right, I'm going to end the poll right now. Okay, all right, very good. So what I see is that the majority is coming in from Miami-Dade County right now, and then some are not located in Florida. And we have a lot in Broward County and Palm Beach County as well. And so I don't see any from any other counties, which is fine. We love that our local Broward County and our Miami-Dade counties joining us. The other poll I'd like to basically launch is just to see if you need any assistance or any services, what would those really be? Would it be in contract sourcing, business resources, anything you need, financial services, exporting, certifications, and all of that. All right, just give it another second. Wow, I see a lot of people needing certifications. I help with that a lot. I pretty much understand what is needed for certification. So if you want, you could definitely reach out to me. That's something I could help with. I see people are in the need of capital. I know that that's a big need for sure, for funding and contract sourcing. So yeah, and legal aid, and Callan will tell you how she can help you. So that's wonderful. All right, so I'm going to end this poll right now so we can get right into our program. So at this time, this is, again, the highly anticipated part of the program. And I really, really enjoy working with Callan. I really enjoy these web series that we have been hosting. And it's my pleasure, really, to introduce her to you. Our presenter today is Callan Soldivini. She goes by Callie. Which is pretty cool. She is a public interest attorney who is dedicated to helping those with unmet legal needs. She is a transactional business attorney and was a civil prosecutor. She wears many hats in the community, as you will, if you get an opportunity to work with her, so you will understand that she's an advocate for the underserved areas, and her goal is really to promote economic development and to stimulate growth in our communities. She also teaches. She teaches courses in ethics and business law and corporate social responsibility and conflict resolution. So she does a lot. She currently works with the FCDL as an attorney at Legal Aid Services of Collier County and Broward County. And of course, today she is with us, joining us to really give us some knowledge on intellectual property. So please join me in welcoming Callan Soldivini. Callie, you can take it from here.
Hi, everybody, and thank you so much for taking your time this lunch to learn a little bit about intellectual property and how it can affect your business. Sidonia, it says that host has disabled participant screen sharing.
All right, let me go ahead and fix that really quickly. Sorry about that.
No worries. And while she's working on that, I'm still going to talk about a lot of topics that relate to intellectual property, but really everything in this presentation is meant to convey general information. So depending on your specific situation, I always advise to retain and consult with a qualified attorney on anything I discuss. But I do hope to touch on some general matters. Okay, great.
Good to know.
Okay, and then just to make sure, can everyone, let me play.
Yes, we can see you for sure.
Great.
See the screen.
And as Sidonia briefly mentioned, I work for Legal Aid Service of Broward and Collier County. However, we have clients throughout the state. And what we do is provide free legal representation to small businesses owned by low to moderate income individuals. So that means up to 140% of your area median income. So for example, for a family of just one, that's about $70,000. For a family of four, about $90,000. So we do have a lot of room to be able to take clients and provide free legal services. And then we also do represent nonprofits serving low to moderate income communities. And our legal services most commonly include incorporating your business if you're new, as you'll talk extensively about today, trademarks and other intellectual property considerations. We can draft partnership agreements, contracts, leases. If you have a dispute going on, whether it's a contract dispute, a lease dispute, we can help by representing you in that dispute. We create client template agreements. Really what we try to do is be a free legal in-house counsel for our clients. So if you qualify any legal matter that comes up, we do our best to be able to solve for you. And today we're going to talk about various intellectual property, and it is an intensely confusing topic. There's a lot of gray area. There's a lot of litigation when it comes to trademark, and so I just want to talk about the ways that this can affect your business. So we'll talk about the differences between trademarks and service marks, patents and copyright, which are kind of fit under the overarching umbrella intellectual property. And then I'll briefly touch on non-disclosure agreements, or NDAs, as it may relate to intellectual property. So the four kinds of intellectual property are patents, which are most similar to an invention, something that you invent. A trademark identifies a source of a product or a service. A copyright is an expression of ideas, like a song or a poem. And then trade secrets aren't really something, well, we'll talk about that. It is intellectual property, but really that's secret information with a commercial value. And at the end of the presentation, I'll kind of talk about a different way if you're not really ready to actually register any of your intellectual property, how we can protect trade secrets with NDAs. For trademarks and service marks, again, this is a word, phrase, logo, design, virtually anything that you use to put out into the consumer's mind that identifies the source of the product or your service. So this would be something that distinguishes you from your competitors. So an example of a trademark would be, of course, the Coca-Cola symbol, or on the right of your screen, a service mark, the Intuit TurboTax. Those represent that brand, those brands. And service marks, slightly different, are going to be the same thing, words, designs, logos, but used to identify the service you're providing. So whether you're providing products and actual goods or you're providing services, you likely have a mark that you identify with your company that's, you know, an asset of value to you. And what does that mean? It means that the owner has exclusive right to use the mark and prevent others from using the mark on similar products until the mark becomes either inactive if you stop using it, or generic. And the perfect example of it becoming generic is aspirin. They once had, it was a company, they once had a trademark for aspirin, but then everyone started calling it aspirin, and the argument is that they can no longer trademark it because we use that as a generic term now, even though it was once a trademark. And I get questions all the time about clients wanting to trademark something that's really common. And really, you can't just trademark, it's really difficult to just trademark anything. Cool shoes, that's probably not original enough. The more original, the more distinctive you can get with what you want to trademark, the more likely that you'll be able to protect it from trademark infringement, and the more likely that you won't have any competitors attempting to infringe on your trademark. So there's a lot of ways we can do that. One way is it can be a fanciful or made up word. For example, Exxon. Exxon is not a real word, but the gas company made it up, and that's going to be really hard to argue that's very easy to argue that anyone that uses the word Exxon is infringing on a trademark because it's totally made up by then. So that's really good to be able to protect. Another way is to use arbitrary words. So it can be an existing word, but without any relationship to the product or the service that you sell. And perfect example is Apple computers. Apple has absolutely nothing to do with computers, laptops, and phones. So that's really easy for Apple to be able to defend Apple computers against trademark infringement. Then it gets a little less protective, but still suggestive products like PlayStation. You can describe your products. creamy something, and then generic names. This is the least amount of protection you're going to have. Pink soap, it's probably not distinctive enough, or small phones. So the more you can get fanciful or arbitrary or distinctive as it comes to the trade or product you're selling, the more likely that you can get a trademark, and the more likely it will be that people won't want to infringe on your trademark because it's just so obviously belonging to you and your individual product or service. So how do you register a mark? First thing you want to do is make sure that no one else is utilizing your name or your mark. So you can search what's called the USPTO database. You just type that into Google, USPTO database, and you can start searching for similar marks that you're considering trademarking. Now the key here is that you want to search it in the same class. So if you want to call your shoe company Apple Shoes, that's not necessarily a trademark against Apple Computers. Apple Computers has a trademark for computers and technology, not shoes. So you want to make sure that you're searching USPTO by the class. If you sell apparel, that's a class. If you provide event planning services, that's a class. If you provide, sell hair products, that's a class, makeup. So whatever it is, you want to search in your particular class of whatever your product or service is and see if the name or logo or mark comes up. If it does come up, then you don't probably want to go down that road. You'll likely be infringing on someone else's trademark. If nothing comes up, then it looks like you're in the clear to take that word, logo, design, and trademark it as your own. So you want to determine your filing basis, and this means whoever is first in line to use a name or logo, they have first rights. So if you do know of someone else's logo and you're like, that's really cool, I want to use that name or that logo and I'm going to trademark it because they haven't yet. If that individual is able to prove that they've been using that marker logo first in time, so before you were, even though you trademarked yours first, that's going to create a lot of problems and you could still be considered infringing on a trademark. The cost for the application ranges. It's about either $225, $275, or $400, depending on what you're trademarking and what the class is. And if you want to just register in the state of Florida, that is an option. So not just nationally, but if you're only concerned about registering in the state of Florida, it's a much more economical way. It is $87.50, and it just protects your trademark in the area you do business. So if you have a cleaning service, you're probably not too worried if someone wants to take your trademark in Nevada or New York or California. You're probably only concerned about Florida. So this is a much more economical way is to register a trademark just in the state. But of course, if you can and you are worried about national trademark infringement, national is the way to go. And really, once you submit your application, you'll likely work with what's called an examining attorney until the trademark is approved. So as I mentioned, if it really comes into who is using a trademark first, that person gets the best protection, even if someone else trademarked. So you want to know, do I have a right to the name if I don't register the mark? You absolutely do. You don't have to register it, but the registration gives certain benefits. One is if you didn't register, you have to argue a common law mark right, and that just means you have to pretty much prove that you've been using the using the trademark, and that trademark does actually confuse consumers and make them think that someone else's product or service is your own. So if you don't register, you have some more work to do if you want to protect your trademark or service mark, but you absolutely still can. You just have to prove that you've been using it before the other party. If you do trademark it, you have a presumption of exclusive use and public disclosure of the registration, so it just becomes a lot easier to defend your trademark against trademark infringement. It's infinite once you register, as long as the mark doesn't become generic like aspirin. And you're entitled to automatically certain statutory damages if someone does infringe on your trademark. So that's probably the best asset of registering your trademark, in my opinion, because you're not going to a judge and saying, "Judge, this person is infringing on my trademark, and they need to give me damages or money damages so that I can recover, because now they've confused my consumers and consumers aren't sure who's who." It's going to be really difficult to prove. It'll cost a lot of fees to be able to prove it. So instead, if you register it, you get what's called statutory damages. So a judge can go and look and says it's a $1,000 minimum fine up to $200,000 maximum per mark infringement. So it just makes it a little easier if you do have to protect your trademark and ask for money damages. A downside, though, is that registering a trademark with the U.S. does not offer foreign registration protection. So it's going to be really difficult to protect your trademark if someone in China uses it, because registering it here in the States isn't going to protect you there. And as I briefly mentioned, a more economical option, and an option for someone that's not concerned necessarily with national registration, is you can register through the state, your trademark or service mark. And similarly, it prevents other entities in the state from being able to use your mark or service. So one thing I get a lot of questions about, and it's a great question, is a client will ask, I registered my business on sunbiz.org, and my business is, for example, My Rainbow Cupcakes Incorporated. Well, no one else in the state of Florida can register My Rainbow Cupcakes, Inc. That's your name under sunbiz.org. However, someone can still register a very similar name, such as Rainbow Cakes LLC. So it could still cause potential confusion for consumers because the names are so similar and they might even be doing the same thing. They're both selling cupcakes or cakes. So even though you get a lot of protection, no one else can use your exact name when you register on sunbiz.org, you still have to worry about someone coming up with a really similar name and even in the same industry that you're working in. I also get a lot of questions about fictitious names or DBAs. So if you are My Rainbow Cupcakes Inc., but the sign outside of your business says Rainbow Cakes, Rainbow Cakes would be considered your fictitious name. It's what you're doing business under that isn't necessarily the name that you registered on sunbiz.org. So what you can do is you'll have to register any names besides the one that's your official company's name as a fictitious name or a DBA, and that requires a $50 filing fee with the state. You can do that on sunbiz.org. And then it requires publishing notice in your local newspaper of the fictitious name. An absolutely ridiculous Florida statute, but for some reason they haven't gotten rid of it. So you do get some protections there. However, anyone can, as many people can use the same DBA as possible. There's really not a lot of protection there. So I do want to just note that registering your name and DBAs certainly give you some protection to be able to use the names, but definitely not as foolproof as either state or federal registration of your trademark. So if you're only worried about local competitors or your budget doesn't allow for national registration, at least consider registering in the state of Florida. So that's a lot about trademarks. Yes, and please interrupt the question.
I know you don't mind when I jump in to ask questions. There was a question that came in, and it was specifically about DBAs because you're talking about that. The question is basically, so it says, so are you saying that I can register my DBA as a trademark? So I think that they just need a little bit of clarity on that, because I did hear you mentioned that you can register your DBA, but anyone could pretty much use that name. But I think this just clarify.
Yes, so that's a great question. So if you're using the DBA Rainbow Cakes, another company can also, or individual can also register for the DBA Rainbow Cakes. There can be several DBAs. However, If you want to make sure that your DBA is protected, then yes, you should and can register a trademark for that DBA that you're using. That's the only thing that's going to protect the name, because as many people as possible can use the same DBA.
Wonderful. Thank you.
You're welcome. And I'm sorry, I should have said, as always, please feel free to put any questions as we're going through the presentation in the chat box, and Sidoni will interrupt me and let me know. So moving on from trademarks and service marks, one form of intellectual property. Again, I know that's a lot of information, and trademarks are often really, really confusing. It gets easier when we talk about copyright and patents, in my opinion. Copyright is an original expression of an idea in a fixed medium and deemed copyrighted and belongs exclusively to its creator. So that's a really fancy definition to say it could be a song, it can be a poem, it can be the melody of something, anything that you can think of that you really create, you can copyright. So you want to, the rights of the owner of a copyright can make sure that no one else reproduces that work. They have copyrights to the derivative works, like a book to a movie. They can perform the work or display it publicly, and can publicly transmit the work and prevent others from doing so. And I say that this is a lot easier to register because it's very unlikely that someone else has written the exact same song as you or the exact same poem as you. So it's pretty easy to copyright. What works are protected under U.S. copyright? Examples would be literary works, music works, dramatic works, choreography, pictures, graphics or sculptures, movies, sound recordings, architectural plans. So again, these are things that would be virtually impossible for someone else to mimic. So if you do have something that's copyrightable, it's going to be a lot easier of a process than sometimes than trademarks, in my opinion, just because it is so inherently, obviously unique. And do I have a right to material if I don't register the copyright? Absolutely. However, just like trademarks, you don't have to register your trademark, but it does come with registration advantages. So one is the legal requirement for an infringement suit on a copyright will require you to copyright. So if you want to sue someone for using your copyrighted work, you will have to actually file and have a copyright. Again, you get statutory damages. So instead of trying to prove to the judge how much you're owed, the judge can look to the statute and say that you get $750 to $30,000 for all infringements of one work. If it's willful and someone actually knew that they were taking it, the damages go up even more to $150,000. You get to protect your copyright for generally the life of the author plus 70 years. And one thing to note about copyright, or even patents or inventions, this kind of applies to all intellectual property, is that when you work for an employer and you invent something or you write something, it's what's called a work for hire, and you as the employee actually don't get any ownership rights to that intellectual property. You likely have a contract with your employer saying that anything that you create in the role of your employment belongs to your employer. So that's just always worth noting if you're using your work's resources or it's part of your job to create copyright or a patent, it really belongs to the employer and not you. And how do you register copyright? You can apply online or in person, and application fees range from $35 to $85. And then you deposit 2 samples of your work with the Copyright Office, and that's it. It's pretty easy because, again, it's really easy to show that your copyright work belongs to you. Moving on. Yes.
Hey, Callan, no problem. I have one more question that came up that's related to copyright. Mm-hmm. And let me open it real quick. I went on a competitor's website and saw that they were using some of our very exact phrases. Can I register my website as a copyright or just a section?
The whole website wouldn't work because it has to be something stagnant, and you're probably updating your website regularly. So a website isn't really something that you would copyright. But if you do have certain slogans or unique images, that's something that you could trademark, so that a slogan is something you can trademark to make sure others aren't using that slogan, and you can protect it. And if that slogan can confuse consumers that are in your same industry from thinking that this other website that you looked at could be yours, since they're using similar slogans, then that's something that you can pursue for trademark infringement, but not necessarily like the whole website. You would have to individually trademark or copyright each item that you're concerned about.
Okay. Thank you for clearing that up. I do see some copyright symbols sometimes when I do go on websites.
Mm-hmm.
Is that something that they may have just put there for protection, or they're saying that some of this information is copywritten or has a copyright?
Right. It probably is indicating that it has a copyright. You don't have to do that. You can, but it's just probably going to make someone that might want to take something from your website or wherever medium they're getting it from, and it's going to make it a lot less likely that they're going to want to reproduce it because they see that copyright symbol. So it's not necessary, but if you're really worried about protecting something, it might make someone who wants to try and take it and use it for their own purposes think twice before they do.
Okay, great. But from my takeaway from that is to trademark the phrase, and you are better off there. Okay, yeah. Wonderful. Thanks.
And then moving on from, we talked about trademarks and service marks, talked about copyrights, and then sort of this third level of intellectual property is patents. And patents they have 3 requirements under law. One, they have to be new, novelty. It has to be a new idea. It has to be unique and non-obvious, and it has to be a useful utility, invention. So it must be a functional device or process that's new, unique, and useful. If one of those 3 things is missing, then it's not something that you can patent. And this is also issued by USPTO. And the rights of the owner of a patent get to exclude others from making, using, selling, inventing, or importing that patent into the US. So what is something that can be patented? Machines, articles of manufacture, composition of matter, such as a new plastic or fabric, the process of doing something, so obtaining useful results through a series of steps, you can actually patent the steps, and improvement on a current invention. So there's different types of patents. You can get a utility patent, which protects the way the invention works. You can get a design patent, which is the ornamental appearance of the product. And you can also patent the plans and protect new varieties of something similar being produced. So all very different and all requiring a different kind of patent. And there are what's really helpful, provisional patent applications. So if you don't have this perfect, created, completely finished patent, but you want to be able to protect something you're working on, you can apply for what's called a provisional patent. And this provides a filing date placeholder that in case anyone wants to take the idea that the invention that you're trying to patent. So it doesn't give you any rights and it's not examined, but it's just, again, like your placeholder and filing date that you've been working on this since whatever date. And it's automatically abandoned after 1 year, much simpler filing requirements, and of course lower filing fees. And then you can say that it's patent pending once the application is filed. So this just protects you while you're working on something that's not completely finished. And the patent application and protection is what you have to provide is a drawing or some kind of reproduction. so that they can see exactly what you're patenting. So we want a detailed visual representation. And patents are easy to protect because it's unlikely someone else is coming up with the exact same idea at the exact same time, but a lot of labor intensive to be able to actually give these drawings and designs. It can be extremely expensive. There's a very complex table of filing fees depending on what you're trying to patent that range anywhere from $75 to $10,000. In addition, patents and intellectual property attorneys are very expensive, running, I would say conservatively $500 an hour. So you do want, it is a very expensive endeavor if you aren't able to get through it on your own. The date of an application for patent determines priority. So unlike a trademark and a copyright, the first to file a patent wins. So I'll say that again, the first to file wins. So you do see a lot of viciousness with patents, that someone might be taking someone's patent and registering it. So you want to at least get that provisional patent application in or patent as soon as you can, because whoever is the first to file is likely going to be the winner if there is some kind of lawsuit. And it gives you protection for 20 years. And how to search if your patent infringes on someone else's patent. There's a lot of patents out there, and this is probably the most difficult search of any of the intellectual property, because it just can be so similar from one patent to infringe on another. So you'll want to go to uspto.gov again, and you can start searching there and typing in something similar to your patents and see what comes up. Just doing a general Google search, patents.google.com, will yield a lot of results. And then you can go old school. You can look at textbooks, reference books, and trade journals for exactly what you're trying to patent, and that will give you some information of similar patents out there. And some common pitfalls is really, in, I guess, any intellectual property, but certainly when it comes to patents and inventions, is to, my legal advice is to keep it to yourself. Don't talk about it with anybody, because like I said, first to file wins, and so it's really important that you don't let someone have confidential information about your patent, at least without signing something like a non-disclosure agreement that we'll talk about at the end of the presentation. So if the inventor allows other people to know about the invention before the patent is filed, the inventor may lose those patent rights. So don't disclose your invention without an executed confidential agreement or NDA. And the general rule, there's really not going to be an exception here, is not to disclose anything to the public until some kind of patent application is filed. And then you also want to keep, just in case there is any kind of patent infringement and questions about who was the first to file, keep good laboratory notebooks, so that if someone registers something very similar to your patent, you can go back and show how you came to your thought process, and that sort of can give you a little more proof and protection. So make sure you keep your laboratory notebooks even as you go through your process, to just kind of prove how you got to your process. And then I get a lot of confusion when it comes to intellectual property and trade secrets, because you don't necessarily have to register something and call it intellectual property to get the full value. You can also prevent any kind of disclosure of something like a trade secret. The perfect example of a trade secret is Coca-Cola, who is still holding on to their secret recipe for over 125 years. So that's going to be a trade secret. It's secret information with commercial value. And you do have protection despite registering any kind of intellectual property, because you can make sure there's physical security before anyone can see it. You can limit access to the trade secrets to anyone who needs to know. You can require non-disclosure agreements to anyone that has access to them. And I always get questions, for example, about, can I trademark or copyright my business plan or my customer lists? Or my manufacturing process? Generally, no. This is really a trade secret and not something that you will file something for as intellectual property. And so it is slightly different. And the way that we protect trade secrets is through those written agreements saying that someone can be in trouble and will owe you monetary damages and other damages if they were to share the trade secret. So a trade secret is available for as long as the information remains confidential, as opposed to a patent, which only lasts about 20 years. But the trade secret could be reverse engineered or independently discovered. So if someone breaks in and finds out this trade secret, that's something that leans towards a reason to pursue patent protection or another form of intellectual property, because that gives you the protection in case, and if you're not registering that intellectual property and someone gets access to your trade secret, that puts you in a bit of a stickier situation. A trade secret cannot be disclosed to the public, the information, but if you do want to file a patent or another form of intellectual property, that's actually disclosed in the application. So a trade secret is really secretive. You're not going to submit an application that someone can review or that can be public. You're going to use other ways besides intellectual property registration to protect your trade secrets. So there's not really an answer of what's right. Keeping a trade secret, making sure that you have NDAs and confidentiality agreements with third parties or employees that may have access to it, or registering a patent or some other form of trademark. It's really a personal decision, but it's worth knowing the difference in that there is something you can do besides register intellectual property. You can have a trade secret and protect it through contracts. And that's why I wanted to also bring up non-disclosure agreements when it relates to intellectual property. Again, when one party is disclosing intellectual property or a trade secret to a third party or an employee, you're going to want to protect that information. So an NDA is a legally enforceable contract between a person or an entity that has confidential information and a person or entity to whom that confidential information is being disclosed. So what is confidential information? You can define it within your NDA, exactly what it is. And the more specific you can be, the more likely it will be enforceable if you need to enforce your NDA. So for example, client information, patents, trademarks certainly are something that you'll want someone to sign an NDA for. And it does not include information that is considered to be common knowledge or information that predates the agreement. So if it is something that someone can go onto your website and find out, that's not going to be something that you can protect in an NDA. And then the two common ways to use NDAs are with employees. So if you have employees or independent contractors working under you, you might have a business plan, you might have a client list or trade secret that you don't want them to know. You can protect that not necessarily through intellectual property registration, but through an NDA. And then you may have third parties. Maybe you're considering selling the business or you're working with a vendor. Then that would also be a situation where you can have them sign an NDA that any information that they discover through your relationship remains confidential. And the best way to protect yourself is to specifically define what confidential information is, because I'll admit there are some great free NDAs that you can find online, but if I can give you a suggestion, if you aren't able to hire an attorney or you don't qualify for our program that provides free legal services, the best way you can protect yourself is take that agreement and make the confidential definition of the confidential information as specific as possible, but also leave it open to if there's something you didn't actually think of, and include that little phrase, including the following, but not limited to, so that you can say, here's the considerations, but also if something just seems confidential, even though it wasn't specifically included, that can also be something that you could sue for.
Hey, Callan,
Mm-hmm.
I have one pop-up question that just says, so does the attorney sign the NDA as well?
If you sign with an attorney under their rules that regulate their profession immediately and automatically include a confidentiality relationship. So there's probably something your attorney will sign in what's called a retainer agreement that spells out the relationship between you and your attorney, that will say that, you know, everything in these attorney-client matters will be confidential information.
Okay. I have one from Pat, and you had moved on. I didn't want to interrupt you at the time. But if you can, I'll just go over it if you're able, or if you want to wait until the end.
No, that's good.
All right, very good. Okay. It says, I've heard horror, it's actually a two-part question. I've heard horror stories about people stealing other people's idea. Isn't the internet search to check an idea very risky? And then it says, an attorney told me that a Google search can reveal my ideas to highly sophisticated marketing company that are looking for new ideas.
That could be true. You know, if you're searching something that's truly unique, and then it's, you know, kind of creates a history for itself and within Google that someone was researching this new, novel, non-obvious, useful idea, that could happen. But it's just a necessary evil, in my opinion, in order to make sure that if you are going to spend the time and the enormous amount of money to register your patent, to make sure that you aren't denied because your patent's actually infringing on another registered patent. But the best means, in my opinion, is through uspto.gov to search, because it sort of eliminates the Google concern that you're, you know, leaving a trail through Google. But that's a really great question. If you do have if you are doing that, then again, I recommend having the some kind of proof that, you know, keeping good records of your patent, so that if there is any kind of issue, you can prove that you had the idea first and it was stolen from you. But again, that's a really tough, I've said the intellectual property is really confusing. There's a lot of gray areas. Technically, with patents, the first to file wins. So making sure that at least you have good notes so you can try to argue someone intentionally stole your patent, and that might help.
Okay, thank you. Very good tips.
And finally, about enforcing your NDA, I said that you should put in there the definition of confidentiality as specific as you can get it, but also outline the remedies for a violation. If someone were to take something that is confidential to you and use it, maybe try to define what those costs are, or how it will harm your business if someone were to do that. That will make it a lot easier for a judge to be able to give you what you're asking for if someone violates your NDA. However, in most cases, the ultimate enforcement of an NDA is going to be a breach of contract claim. So you'll have to actually file suit for a breach of contract. The NDA is the contract. And I know that this is a really intense topic, and it's really confusing, and a lot of times clients ask me questions and I can't, and it's frustrating for them because I can't give them a clear answer. There's so many gray areas. Another not so great thing about intellectual property is that if you do want to file a lawsuit to enforce protection against your patent or trademark or copyright and prevent it from being infringed upon, litigation in this is extremely expensive and lengthy. As I mentioned, there are they have intellectual property attorneys that specialize in just this area. That's how complicated and complex it is. And the laws, federal and state laws, and the case law that judges are actually deciding, it's just very confusing. So much so that there is an actual bar exam specifically just for attorneys that want to specialize in intellectual property. So when you are filing a lawsuit and you are trying to protect yourself from trademark infringement or patent or copyright infringement, it's not just because you're in the right doesn't mean that this is going to cause extreme headache and concern for you, because the litigation could take several years. And again, very, very expensive. I know intellectual property attorneys that can charge up to $1,000 an hour for their work. So in a perfect world, if you register your trademark, or you have an NDA, or you register your patent, and someone tries to take your intellectual property, and you're right, you're in the right. You've either registered, or you have an NDA, or you protected your trade secret. It's still a horrible process to have to litigate this when you need to enforce, that agreement or that infringement. So it's not a very uplifting presentation in that it's just a lot to have to protect something. But the clearer you can be, if you have an NDA, again, spell out your remedies. The sooner you can file, if you do have the funds and the capability to be able to file a national or state trademark or service mark. Definitely for patents, it's going to be really, really important to file your patent because it's first in line, not necessarily who had the idea first. That's going to be a really important part of your business plan to be able to make sure you're accounting for that, because even if you do have to litigate, it's extremely time demanding and expensive. And I appreciate you all bearing with me for this really intense topic of intellectual property. And this is often something that's easier to answer when there's specific questions as it relates to the specific situation. And again, everything in here is general, but if you do have a specific situation and qualify for our free legal services, my contact information is up on the screen, and I'm going to leave it there for a few more seconds before I take it down and turn it back over to Sidoni. But thank you all again for joining me, and I hope that everyone got a little bit of taste of what intellectual property is, how complicated it is, how difficult it is to enforce and expensive, but at least know some ways that you can best protect your business and your ideas. Thank you.
Right. Well, thank you, Callie. I've certainly learned a lot. I always learn so much when you go over your presentations. We're still in the Q&A hour, so if you guys have any more questions, please let us know. I do have 2 questions, so I'm going to go to them, and then again, feel free to ask your questions. All right, so let me go to this one. It says, do I need to register logo, website, and company name, or would that be too much? And I'm assuming that's about trademarking.
Yes, that would be a trademark. And if you can't afford to do all 3, that's great, you should. But most times people don't have, the budget they need to be able to register every single name they want to use. For example, you might have your business name, like you mentioned, your website name, and then a slogan or a phrase that you identify. If you can register all 3, that's great. I would do that. But if, your budget doesn't allow for it, I would pick, the one that's most important to you and do that. And don't forget that their trademark, actually registering a trademark or service mark does have benefits for sure. But if someone does try to take your trademark and you were using that trademark first and you can prove that, you still get a lot of protections if you're not able to afford to trademark all 3. And then I do have another question in the chat box. What are the qualifications to use the free legal services? So if you're a small business, all of the owners of the small business can only make up to 140% of the area median income. So you can Google what your county's area median income is. But for Broward County, for a family of 1, about $70,000. For a family of 4, about $90,000. So if you're close to that threshold, I'll put my email box up. Go ahead and send me an email and we can see if you qualify. And then any other questions before I stop sharing?
On the screen, that last page has your contact information. If you want, you could share that as well. Yeah, there was a question that came in that I accidentally dismissed, but I do remember it. They were asking about national versus state trademarking, if someone had the mark already nationally, if they can still do a trademark locally? Or
No,
for
if
the-
someone has it, that would still be infringing on the trademark. The benefits, I generally recommend to my clients, if they're small businesses, and I know that they're not going to franchise, I know that they're not going to be doing business in Washington. It's just more economical. It's a lot easier of an application. But if there is someone already using the trademark or service mark in USPTO nationally, it would still be considered a trademark infringement if you did the Florida state filing.
Okay. All right. That clears up a lot, because I guess if they can afford it, just go ahead and try to trademark nationally,
Mm-hmm.
right?
Exactly.
That's probably the safest way to go.
Right.
Very good. Well, I have no more questions on my end. So, I want to thank everyone for really joining us and coming to this program. I really enjoy every single minute of Callan's help here, and her knowledge. I've gotten so many great feedbacks. I'm like the background person speaking, so that's fine. I just really want to introduce you to the next set of events that are coming up. But first, really to acknowledge Callan and her work and how she's helping everyone in the community that really qualifies in all these other businesses. So we really do appreciate. I do see one other question coming up. Let me see, Callan. I'm sorry. Let me.
No worries.
Well, I'm sharing my screen, so it's not allowing me right now, but I'll try to go back to that question if you don't mind. What I really wanted to show you here is that you could go on the website, and a quick way is to really register for the next event. It is on the 27th, which is next Thursday at 12 o'clock. We're doing these lunchtime series. They've been very effective. I've had some feedback on that. And the next one is really talking about bonding, and it's good to chime in or to actually to view it, because you might need bonding at some point if you ever plan on doing business with the government, or sometimes some very large corporation. If you plan on doing large business type of events, or not even events, type of contracts, getting any contracts in that way. So I'll just stop sharing here. And it'll go back to the questions. Well, actually, it was just a comment. It says, thank you for all your help. Another one said that they really enjoyed the presentation. So, of course, thank you, everyone, for joining. Thank you for really your time and your efforts, and everything that you have put forward here. It's a tough time, and we're just here to support businesses. We're here to support you in whatever way. Again, my goal is to really help the small businesses in the area that I serve, Broward County, but I still can help in other ways if you're not even a part of the state. So feel free to reach out to us. I'll bring you the experts. I'll bring you the answers. We'll try to research them if we don't know them. And again, just continue to go to visit our website, follow us on our pages just to see what we have going on. Again, the goal is to support small businesses. And again, if you need legal aid, do feel free to reach out to Callan. She's helped me a lot, and she's helped me with trademarking my brand. So that's a success story right there. It's just a testament to her work and everything. All right. So Callan, any last words, being that this is your last session with us?
No, just thank you so much for having me. Thank you, Sidoni, for putting this on with Black Swan Events, and it's been a pleasure. And again, please feel free to reach out if you have specific legal concerns.
Wonderful. Well, guys, now you get your afternoon back. Please do take care, and of course, as always, be safe. Thank you.